It uses no evidence.
That's correct.
Yes. That document, again, when it comes to the matter of Lieutenant General Mdluli, is limited only to the decision to withdraw the charge and to refer the matter to an inquest. It does not refer to the failure to reinstate the charge after the inquest or the failure to reinstate the murder charge after the judgment of Judge Murphy.
That's correct.
That document also does not mention anything wrong with Mr. Chauke's decision to instruct an appeal against the judgment of Judge Murphy in the matter of Lieutenant General Mdluli.
That is correct.
Yes. Thank you. Might we move on to the next topic? When we adjourned, there was a third issue to be dealt with, which was the question of the instruction to Advocate Hilton Epstein. Can I understand what your evidence is? Is it that you don't recall the entire interactions with Advocate Epstein or not?
The position is that I had interactions with Advocate Epstein. I remember that. I recall broadly that he had been briefed by Advocate Abrams in a number of cases, and the meetings we had dealt with the status of those matters generally.
Can you explain why you never disclosed this episode of the involvement of Mr. Epstein, despite you being completely aware of that fact?
I didn't think it was relevant at the time. But I'm here to answer questions. I'm happy to talk about it.
Yes, so it's not about having forgotten. It is about a deliberate choice that you will not disclose it because it's not relevant.
No, that's not correct. If I can please clarify that. It was not a deliberate choice. It's not like I thought about my interactions with counsel, Advocate Epstein, and decided not to put it in. That's definitely not the case at all. We were trying to put together my affidavit, and I think maybe we need to go back to the timelines under which we did this. And I think everyone is aware of that, so I won't go through it again. But I had a couple of days, amongst other things, an appearance before Parliament. I'm not making excuses. All I'm saying is that we tried to put in my affidavit aspects that we thought would assist this inquiry. And I'm not trying to withhold that. I didn't even think about Mr. Epstein at the time, but I'm happy to discuss any aspect of my meetings with him. I've got nothing to hide at all.
Now,
Madam Chair, with your permission, may I ask to interpose with respect to my learned colleague? I'm advised by the NPA team that at the time of the settling of the NDPP's affidavit, there was no instruction about the Epstein issue. And I'm asked to convey that and to put it on record.
I don't understand, counsel. Are you suggesting that the issue regarding interactions between Advocate Batohi and Advocate Epstein was not brought to the evidence leading team?
No,
Or what?
was not brought to the attention of the NPA, rather the attention of Advocate Hali at the time, and the evidence leading team as well, when the affidavit of the NDPP was settled. In other words, it is a response to Advocate Nqcukaitobi's issue that Advocate Batohi has not bring that to light in her affidavit, disclosed the interactions in her affidavit.
And Advocate Batohi sought to answer that question the way she did. Are you taking issues with her answer?
Not quite. I was just asked to put it on record. I'm not taking any issue with it. Her answers will remain. Those are her answers.
Shouldn't you leave this aspect for re-examination, because those are matters that you can clarify maybe in re-examination?
Yes,
Not now.
I agree.
Thank you, Madam.
I see Advocate Halley is raising the hand. Would you please confer with him?
So we should encourage our children so the entire line is based upon questions which we will consult with our witnesses. I don't believe our witness must be
Madam Chair, Advocate Hali is requesting that he be given an audience on this aspect.
We will confuse this record. As you know, senior counsel, you will have an opportunity later when you re-examine. We cannot have cross-examination and re-examination at the same time. Might I request, through you, evidence leader, Advocate Mhlamunyane, that you take note of this aspect, and at an appropriate time when you re-examine, if you are minded to do so, you can raise whatever you want to raise.
I take your point, Madam Chair.
Yes, thank you.
Yes.
You may proceed, Advocate Nqcukaitobi.
Thank you, Madam Chair. Advocate Batohi, could you go to page 253 of file 3?
I'm there.
Yes. Now, that is an email that we received on Monday from Mr. Epstein SC. That was sent to you on the 26th of February, 2019, in preparation for a meeting to be held on the 6th of March. Correct?
It is the letter. It is an email from Advocate Epstein to myself, dated 26th of February 2019. That would have been about, I took office on the 1st of February 2019, so it's within that month. And I'm not, I can't recall the meeting on the 6th, well, whether it happened on the 6th, but as I said, I had a number of meetings with him. So it might have been in preparation for that.
One of the documents that were given to you is the document that appears at page 254, which is a note prepared by Advocate Epstein and his junior Advocate Govender.
I see that.
Yes. Now, in that note,
Advocate Nqcukaitobi, how do we know that this document at 254 forms part of a note that was prepared by Advocate Epstein and Junior? Just by mere looking at the document, how do I know that?
what they did, Madam Chair, at item 1 of 253, they did not only just extract the, if you go to 253, item 1, there are documents attached. And the first one that was attached is this document at page 1 to 5.
He's verified with the witness.
Oh, yes, thank you. Thank you for the guidance, Madam Chair.
Yes.
Yes. Advocate Batohi, we consulted, as you know, with Advocate Epstein to get.
I was not aware, but you did ask, and I had no issue with that.
Yes, well, we had asked on Monday whether there was an issue that you took on the advice that was given to you, and you said no.
That's correct.
Now, what he tells us is that in preparation for the meeting of the 26th, they sent several documents, which included the note on advice at 254 to 258. The document at 259, which was an extract from the affidavit of Mr. Sean Abrahams, and then references to case law, which you will find at 274, and then the prosecution memorandum at 278. Do you accept that, or you have no recollection?
My office has been trying to track the emails, and for some reason we were not able to go this far back. We were struggling with it, so we've not able to trace these. But he did brief me on a couple of occasions, and I don't have any reason to doubt that these documents would have been part of a pack that he would have sent to me. But as I say, I don't have any independent recollection of it.
Yes. Well, in the consultation, Advocate Epstein also read out to me and my junior WhatsApp exchanges with you. And I asked him not to copy those because I felt that would be too intrusive. Your evidence is that you have no recollection whatsoever of these emails.
No, I have no recollection of the contents, but we certainly had communications.
Well, you say you asked your office. I don't understand that. You asked your office to track these emails and they drew a blank.
Yeah, there's even the dates of the meetings. Our calendar, for some reason, was not taking us back to 2019. So my PA was having some difficulty actually getting the dates of the meetings as well. I don't know what the issue is.
So from your side, there's just nothing about 2019 on this particular issue.
I don't have anything in front of me at the moment. I'm seeing it now for the first time since then.
No, the problem with this is that there are other documents from 2019 that you produced for this inquiry.
Yes, that's right.
And then suddenly this one has drawn a blank.
See, the other documents were attachments or annexures, or they were attached to other documents. So we were able to, but I asked my PA to please try to trace the emails as well as the dates. And for some reason, we're not able to do that. I don't know why. I can't explain that, but it's in my interest that I have all of it.
No, I don't understand why you are able to get some documents from 2019. And then when it comes to these interactions with Mr. Epstein, which you never disclosed, you can't find anything.
I have no reason to hide my engagements with Mr. Epstein at all. I'm not withholding it for any reason. I'm telling you, I had the other documents that we may have got, like Advocate de Kock's report, was one that was attached to Dr. Broughton's annexure, his affidavit or his opinion. And I'm trying to think which of the other 2019 documents we would have had. But it's not like we searched for those documents now. I didn't ask my office to do that. I did ask them to check for all my engagements with Mr. Epstein, including dates of meetings, etc. And I don't know why we are struggling with it.
Yes. If we then come back then to page 254, just to understand, is your testimony that you have no recollection of page 254 at all?
I have no recollection of page 254 at all. I'm seeing it for the first time since I would have if it came to me then, I've got no reason to doubt that, but I'm seeing it now for the first time.
Yes. So what they told you, Mr. Epstein SC, as advice, of course, you can say it's legal principles. Paragraph 1 and paragraph 2, those are the principles when poker certificates are issued because you asked for it.
Mhm.
At page 255, they told you what you are entitled as an NDPP to rely on, which was one of the points of attack against the decision. They also told you, most crucially, what is the case against Mr. Boysen, Major General Boysen, apologize, at page 255, 256, right up to 257. They also told you to justify the rationality, because that was one of the issues that were challenged.
Please take it one step at a time.
Oh, sorry, I apologize.
For Advocate Batohi to respond, you referred first
But perhaps-
to 255.
Yes, we can go back to,
257.
yes, Madam Chair, thank you for the guidance. We can go back to 255 so that we get an answer per question.
I would prefer to answer it completely. I'm making
Generically,
a note.
I see.
I'm making a note. If you can go a little slower,
Yes,
it will help.
all right.
Thank you, Chairperson.
Yes. Now, the reason why they prepared this note is that you had asked for their views on the issue of the application brought by Major General Boysen, which had been defended by Advocate Abrahams. Pleadings were closed and the matter was due for argument. They sent you a short note to prepare for the meeting. Let's stop there. Any recollection?
I don't doubt that.
You don't doubt it?
Mhm.
Yes. Now that note, as most legal advisory notes would say, starts off with general principles, paragraphs 1 and 2, which is page 254 and 255. Is that correct?
It does.
Yes. And one of the points that were attacked in that application is the question of the extent to which Mr. Sean Abrahams could have relied on summaries prepared by junior prosecutors. I don't mean junior in years, but junior to him. And then they gave an opinion on that at page 255, and that decision makers are entitled to rely on summaries, correct?
That's correct.
Yes. And then most crucial.
Where in paragraph page 254 is mention made of the reliance on junior advocates?
No, it is
Remember
at
we-
255.
You must remember, Counsel, we have presented this document for the first time to us this morning,
Yes,
meaning we have not been able to go through it.
I appreciate it.
So give us the details as you ask questions and take us to the relevant points as regards your questions.
Yes, thank you, Madam Chair. So if you go to 255, under decision makers are entitled to rely on summaries, it says, this is a principle of law, and they're explaining to you why it is correct. They say this is consistent with the wealth of authority affirming that decision makers are entitled to rely upon summaries of underlying material prepared for them by their subordinates,
It's correct. It's a point that I've also made at this inquiry.
who are well versed in the matter and whose judgment and ultimate decision maker is.
I beg your pardon, Counsel. You just made a remark. What are you saying, Madam?
I said that is correct. It is also a point that I've made at this inquiry. So I agree with that.
But you answered the question whilst Counsel is busy continuing with the question, or did I misunderstand you? Advocate Nqcukaitobi?
Yes, I had not yet finished, but we can live with the answer that the witness accepts the proposition.
It does help us because we are recording
Yes.
your questions for our own purpose and the answers, Advocate Batohi. It will be helpful if you can just take a deep breath and wait for Counsel to finish. Because you write a question and before it is concluded, you answer. It is making it difficult for us.
Understood, Chairperson.
Yes.
You may proceed, Counsel, maybe from where you were,
Yes. Thank you.
so that you can get the answer from Advocate Batohi.
Yes. After the word subordinates, comma, who are well versed in the matter and whose judgment the ultimate decision maker is entitled to trust. So that's the advice they gave you on that issue, correct?
It's there. It's in the document.
Yes. And then one of the most important issues, I wanted to come to this page 255, that Major General Boyson kept on repeatedly saying publicly that there is no case against him. They then sought to condense the case for you. What is the case of the NPA against Major General Boyson? Now that is stated at page 255 under the heading, the case against General Boyson. And then they explain to you in paragraph 1 that the applicants challenged the decision of Advocate Abrahams to prosecute Boyson on counts 8 to 12, the 5 predicate offenses in the indictment. And then they explain what the defense of the NPA is. From paragraph 2, paragraph 3, paragraph 4, paragraph 5, 6, 7, 8, 9, 10. They also even, at paragraph 10, give you the basis for that case, the factual basis for that case.
At paragraph 10.
Yes,
Sorry.
paragraph 10, page 256.
Mhm.
They say witness statements are relied upon, as well as a statement by Danikas, a police reservist who worked closely with Boyson, and corroboration by ballistics reports supporting the allegation that those killed were not in fact resisting arrest when they were killed. Now, those 2 pages are pieces of advice to explain in very condensed format what is the case against Mr. Boyson. And they're doing it to prepare for the meeting of the 6th of March. Is that correct? That's the advice they gave you?
That is the advice that they provided in this document.
Yes. You then turn to page 257. Now it's going into a different topic, because one of the issues is to challenge the rationality of the decision by Advocate Abrahams. That is covered under the heading, the decision made by Advocate Abrahams to issue the Section 2 COCA certificates. And that's paragraph, they even tell you there, a presentation to guide Advocate Abrahams through the evidence was made to him on the 27th of August, 2015. It is an annexure, JB 27. Then Advocate Abrahams told the prosecution team that he wanted additional information to be obtained and investigations pursuant thereto to be conducted. Advocate Abrahams requested a list of items. After these were furnished to him, he was not satisfied and instructed Advocate Maema to travel to Greece to consult with Danikas. Then paragraph 4, Danikas supplemented his statements and handed Maema additional photographs and video clips on flash disks. Dawood Adam and Advocate Maema briefed Advocate Abrahams regarding their consultations. He was handed a copy of Danikas' supplemented statement, and he was shown certain photographs and video clips on the flash drives concerning the manner in which the Cato Manor Serious and Violent Crime Unit dealt with suspects. And then Advocate Abrahams then issued the COCA certificates. Now, I asked him about this. This is to explain the rationality of the decision by Advocate Abrahams. Do you accept that that's the advice you received?
This relates to the rationality, and that's an important point that you make.
Yes, yes.
It's not about the correctness, it's about rationality.
I understand, but this is the advice they're giving you.
Sure.
Yes. And then the final page.
Sorry, Advocate Nqcukaitobi, can we seem to be getting answers, but one is not clear whether the witness accepts that this is the advice that was given to her or not. Her latest answer is sure. So I don't know where to place sure.
Thank you, Madam Baloy. Could you answer expressly? I am putting to you that this page 257, under the heading, the decision made by Advocate Abrahams, was the advice given to you on the rationality of the decision by Advocate Abrahams by Mr. Epstein SC. Yes.
That is correct.
And then they sum up the whole thing at page 254 by referring you back to legal principles.
Sorry, at what page?
258, sorry, I think, or did I say 254? Yes, page 258, which is the last page where they sum up these requirements by reference to section 2, subsection 4. And there they draw your attention to the reasoning of Judge Scott J.A. And in the judgment, firstly, there's a judgment of the Western Cape Division in paragraph 1, S versus Chau, and that judgment is already referenced earlier at 254. Can you see that?
Mm-hmm.
Yes. Then they support it with another authority, NDPP versus Moodley and others. And then paragraph 3, to sum up why they believed that the decision was defensible.
Sorry, where's the sum up?
This is the sum up, what I'm referring to you, because it's under the heading, the requirements for a section 2.4 COCA authorization, page 5.
They set out the requirements there.
Yes, yes, page 258, correct?
Yes, they mentioned 2 cases and set out the requirements.
Yes, exactly. Now, this note is given to you because you've asked for it in preparation, because you want to understand the strength of your case, correct?
That is indeed so. I wanted to understand the position that they were taking and the reasons for it.
Exactly. You know, when I asked you on Monday, are you sure that you never received written advice from Mr. Epstein SC? You started by saying, no, you didn't. Then later on, you said, no, I don't recall. Now we know for a fact that you did receive it.
That is so, I couldn't recall. As I said at the time,
Beg your pardon, Advocate Batohi. What is your response?
Chairperson, my response is, as I said, I could not recall. And I want to clarify that I was very clear that I had meetings with Mr. Epstein and that I received documents from him with regard to cases that he was handling at the time for the NPA. So, you know, that was what I could recall. Maybe the specifics of it, I couldn't, but I certainly accept that he had given me these documents. At the time, he provided me with documents.
No, you see, the problem, Advocate Batohi, you've given us so many opinions from your office that you obtained. And on this issue of whether there was a good case or a bad case, or at least what the case was, let me not, because I suppose you will disagree if it was a good case, but at least what the case was and what the defense was. You've just not produced this advice from Mr. Epstein. Now, that I find extremely difficult to understand why you did not volunteer these interactions and this opinion. If you are saying there was nothing untoward, then I ask myself, why then not disclose it?
There is still nothing untoward about it. And I've explained, I thought, why, we didn't provide it. And as I say, this is the first time I'm seeing it, but I was candid when I was asked about it, that we had had meetings and he had briefed me on all the matters that he was handling. And of course, this was one of them.
Well, we will have to look at the record about whether you disclosed that there were meetings. I thought I introduced Hilton Epstein SC into the discussion, not you.
No, you're right. In fact, you did. If my recollection is correct, that you did. And I said, when I was asked these questions about it, I answered it as candidly as I could.
Yes. Now, the other documents from 254, right up to from 259 to 333 were also part of that attachment. We can see from the email cover that they were part of that attachment. 259, Madam Chair.
259.
Up until 333.
What about them?
I'm saying to the witness that they were part and parcel of that email exchange that is referenced at 253, correct? Actually, it's not an exchange. It's
Sorry,
Mr.
my
Epstein sending
apologies.
you an email.
I was just looking at all of the attachments, and I do see a minutes of meeting of 6 March as well, which I haven't seen.
Well, I'll come back to that minute. I just want to look at the attachments.
Chairperson, I asked that I be given an opportunity to read all these documents and then deal with them, because it's the first time that I'm seeing it. And I think it would be fair for me to have a look at these documents and then be subjected to questioning on it.
In fairness to Advocate Batohi, remember, we all have these documents only this morning. And I'm sure she would like to refresh her memory, as we wish to also, because we have not read the documents. It may just be useful for her in particular to reflect. If it is possible, you may park this question hopefully it's not going to inconvenience you or distract you from your course, just to enable her to reflect on this document, particularly from 259 to 333.
Look, Madam Chair, if she's going to reflect, she must reflect up until 353.
353.
Yeah, so that we don't come back and then stand down again for another questioning. Madam Chair, I have no difficulty that a witness who's asking for time must be given time. I want to record one thing. These are documents that were sent to Ms. Batohi in 2019. In other words, these are her documents. She wants to read them, fine. And my position is they are so crucial to the topics that come thereafter. So if she wants to read, she can read them, but I would like to continue questioning her on these documents before moving to the fourth topic.
Okay. You say these are the documents that, I beg your pardon, these are the documents that were sent by Advocate Epstein
Yes.
team
Yes.
to her in preparation for the meeting of the 6th of March,
Yes.
2019.
2019. Yes. But as I say, the principle that a witness wants time and must be respected, I accept that.
Thank you, counsel, for understanding. Advocate Batohi, I beg your pardon. Let me just confirm with my sister. Advocate Nqcukaitobi, as you understood that it is fair. Advocate Nqcukaitobi, as you understood that it is fair for Advocate Batohi to go through this document, would we be able to proceed then on another aspect? Or will it be necessary for us to adjourn to enable her to go through these documents in preparation for your next questions?
Yes, Madam Chair, I don't know how long she needs, but it shouldn't be more than an hour to read through this document. So I'm happy to adjourn until maybe 2 o'clock, and then we can commence thereafter.
We are minded to enable her to go through the document then until after lunch, because we will reconvene and then immediately after that hour, it will be lunch. Advocate Batohi, how much time do you need to reflect and read this document?
Chairperson, I might not be as fast a reader as Nqcukaitobi, but I think let's, up until 2 o'clock, I'll certainly do my best to go through all of it and be ready at 2 o'clock.
I'm just thinking, counsel, that lunch may not necessarily be ready when you adjourn now. So it may be helpful as we afford Advocate Batohi sufficient time to also just use that moment to wait for lunch so that when we reconvene, we would have had lunch to avoid many adjournments. I think that will afford you sufficient opportunity, Madam, to reflect.
I hope so,
and,
Chairperson. I'll do my best.
Go through the documents. It will definitely be more than an hour. In that event, Advocate Batohi, we bear in mind that these were the documents sent to you in your office in 2019. Of course, it's a long time ago, but you are aware that there were such documents. So it's not like a totally new document that you don't know of. Nonetheless, we will afford you 2 hours, not an hour, 2 hours to go through the documents so that we do not take another adjournment after lunch. We will therefore adjourn now for that purpose and also to have lunch during that break and reconvene at 2:30. We adjourn.
As you please.